But is it true, or is it just a cheap, woke fantasy? Well, here's the facts, and the facts matter, so let's look at tail of the tape. How many confirmed visits to the White House? Under Bill Clinton, there were 17. Jeffrey Epstein visited the Clinton White House 17 times. How many times did he visit the Donald Trump White House? 0. How about documented political donations? 21,000 to the Clintons, 0 to Trump. Documented non-Clinton political contributions. 118,000 to the Dems, 18,000 to the GOP, for a total of 89% to the Democrats and the Clintons, 11% to the GOP. Now to the matter at hand. Epstein files released by the oversight Democrats from 2019 to 2023 when they were in charge of this committee. 0. Epstein released files by the oversight Republicans from 2023 to present, 53,000 pages. Epstein files released by the Biden Department of Justice in the 4 years he was in office. Again, 0. Epstein files released by the Trump DOJ, 2025 to present, 125,000 pages. And a member of this committee completely jumped the shark again. And right after Charlie Kirk was assassinated by a left-wing loon, and it was a time where we really need to turn down the temperature and practice some civility, said, and I quote, "Republicans have been so busy protecting pedophiles and rapists that they forgot what this committee is supposed to be about." Well, I tell you what this committee is supposed to be about, Mr. Chairman, about transparency and truth. And on this matter, the Republicans have led, and we produced results, and the Democrats have done squat and bumpkiss. For the record, you know, that kind of incendiary rhetoric, while it may make headlines and make people famous, or perhaps better stated infamous, and raise loads of woke cash, maybe even get you invited to Hollywood parties. But at what cost? Those kind of lies create division and damage, and they're ludicrous, absurd, lazy, and perhaps, worst of all, unoriginal. And I don't think it's going to translate much to Journey to the Upper Chamber. I hope it doesn't translate to that. The Trump administration and Republicans on this committee and on this issue have served Lady Justice by a count of about 178,000 to 0. So the Clintons should come in, honor the subpoena, and testify. And you know why, Mr. Chairman? In the pursuit of truth. Mr. Chairman, I yield back.
Gentleman yields back. Chair recognizes Ms. Stansberry from New Mexico.
Thank you, Mr. Chairman. You'll have to forgive me if I do not give a slow clap to our colleague across the aisle for his Academy Award-winning appearance just now in front of the committee. But I want to just address some of the things that I heard here today and to talk about why we're here. What I've heard here this morning in front of this committee is exactly why the American people hate politics. Because the American people don't care if you're a Republican, if you're a Democrat, if you're an independent, whether you vote or you don't. They want the Epstein files and they want justice and accountability. And they don't give a damn whether or not it's Democrats or Republicans or who is implicated. They want accountability. And that is what the survivors are asking us for. They are asking us to do our jobs, to make good on the promises that we made them when they came and met with us, and to actually, in good faith, conduct an investigation. Now, I always think it's important to pull back the curtain for the American people about what happens in these committees. And I was not shocked and surprised, but, you know, I think it's important to note that when I stepped out of the committee a few moments ago, the press were huddled on the Republican side of this committee room to take statements from the Republicans. They're not out in the kind of like neutral area. They're standing outside the Republican door so that after this vote is taken, our Republican colleagues can walk out and make a statement to the press. Now, I think that that's important to note for the public here, because this is not about true accountability. Because if this was actually about getting to the bottom of this case and actually holding individuals accountable for the crimes that were committed by Jeffrey Epstein, by Ghislaine Maxwell, by the associates, and the many, many people who are implicated in this case, what would be happening right now in this committee is that Pam Bondi and DOJ officials would be sitting right there on the witness panel answering questions under oath, because they are breaking the law. They are not complying with our subpoena. They are not complying with the Epstein Transparency Act. And on the day, the final deadline, that they were supposed to release their final explanation about why they may have redacted some files, and in fact they have, as has been stated many times, only released less than 1% of the files, Donald Trump used the United States military to invade a foreign country and steal their oil. And while we're sitting here and our colleagues are trying to create a spectacle for the media, every single newspaper in the United States and the world's headline is about how Donald Trump right now is in Europe embarrassing the United States. How he is threatening our NATO allies to invade Greenland. Humiliating the United States. And I have to say, I was home over the weekend for Dr. Martin Luther King Jr. celebrations to honor the life and legacy of Dr. King. And the question that I got over and over again from my constituents is, what is in those files that is so bad that President Trump is invading Venezuela, threatening our NATO allies, and sending thousands of armed paramilitary troops onto our streets to create violence and chaos in American cities? That is what the American people are actually asking us. And so I will be honest, Mr. Chairman, I am deeply troubled that the individuals who are the subject of today's hearing did not appear on their scheduled date. No one is above the law. But I do know, based on the correspondence, that they have been corresponding with you regularly to try to resolve this issue. But I don't believe that's what this hearing is actually about. Because if it was actually about getting justice and about getting the truth, we would have DOJ here. We would be holding Pam Bondi in contempt, and we would be hearing from the survivors themselves. And so I have to agree with my colleagues that I believe that this is part of an extended smokescreen to try to cover things up. And so I do ask my colleagues across the aisle, if you are earnest about getting to the truth and getting to justice, then bring DOJ in here and hold them accountable, because that is actually what the American people want. I yield back.
And lady yields back. Before I recognize Mr. Biggs, I want to point out again for the umpteenth time, Pam Bondi is coming in front of Congress under oath, and there'll be lots of opportunities to ask her questions about the Epstein files.
But sir, Mr. Chair, can I ask a question?
She's violated a subpoena from this committee, and she should be held in contempt for that. That's a fact.
Here's the difference. They have been turning over documents. Now, I've said it 100 times. It's not as quick as we would like, but they're turning over documents. And I've been very clear today and in hundreds of interviews.
You can't be serious that one person is turning over documents. What's the deadline for them? When do you expect the full document?
Well, in our subpoena, there was no deadline. And then we voted for the discharge petition, and there's a deadline. The discharge petition's in judiciary. She's coming in front of judiciary. Now, that is a fact. Don't try to and Bill Clinton's not a victim here, and the media is not going to take Republican side on anything.
So let's just be right. I think Pam Bondi.
Chair recognizes Mr. Biggs. It's Mr. Biggs, 5 minutes.
Thank you, Mr. Chairman. And I would just point out, the previous speaker was talking about peeling back so the public can see what goes on in a committee. I mean, I just came from another committee where we were talking about massive fraud around the country, and in particular in Minnesota. And I'm glad that 2 Democrats could find time out of their busy schedule to even attend that hearing. What a shame. What a shame. So when someone says, what is in the files so bad, I'll ask this question. What is in the files that's so bad that the Democrats for 4 years, for 4 years when they had control of this committee, didn't release a single document, didn't call a single witness, didn't make any motion? In fact, for those 4 years, go back and look. Did they ever say anything about Epstein? No, they didn't. But wanting to make a press want to get it on the press. That's why you're making the issue today. Because let's talk about why we need to talk with do this contempt. Is because former President Clinton and former Secretary of State Hillary Clinton basically strung us along as we were bending over backwards trying to accommodate their schedule. They didn't show up after we finally had to get a subpoena for them. And I have right here, this is just interesting to me. This is a little note written by Mr. Clinton, former President Clinton, to Jeffrey Epstein's 50th birthday. Jeffrey, happy 50th. It's reassuring, isn't it, to have lasted as long across all the years of learning and knowing, adventures and, no illegible word, and also to have your childlike curiosity, the drive to make a difference, and the solace of friends. He rode on that plane many times. He was apparently close friends with him. Jeffrey Epstein claims that, and I don't know if we should believe anything Epstein says for sure, but I mean, Epstein says that he helped set up and fund the Clinton Foundation, and former President Clinton in his note. I mean, this is what he wants. He doesn't want to come in and testify. He wants to do the same thing that he did in previous times. Just, okay, we're going to send a little note, that ought to do it. He says something to the effect that he spent significant time in the Clinton Foundation after he left the presidency. Well, if Jeffrey Epstein set it up, then there's some reason to ask questions of both he and the former Secretary of State. They were given a subpoena. It was a lawfully issued subpoena by a standing committee. By the way, I happened to be at that subcommittee hearing. I was there when every Democrat voice voted that out. Nobody objected and said they didn't want him to be subpoenaed. But he was subpoenaed, and he didn't show up. So here we are. And with Mr. Chairman, I'll yield time to you if you need it.
I appreciate it. I think that everything that needs to be pointed out, we've pointed out. So I will.
Then I'll yield, sir.
Okay. Chair, any other members seek recognition?
Chairman.
Mr. Mfume.
Thank you, Mr. Chairman. I want to thank you and the ranking member, and I particularly want to underscore the ranking member's opening statement, and that was that oversight Democrats want the truth about Jeffrey Epstein's crimes and accountability for everyone involved. He said, and I agree, we want transparency, we want the facts, and above all, we want this committee to use its oversight tools in a serious and responsible way. I would be remiss if I did not thank on behalf of all of us the efforts of Representative Rokana of this committee and Representative Massey. Thank God they stood in the way of things and took the heat to get the discharge petition up and voted on. And I want to also point out something that I think is important, and that is consistencies, Mr. Chairman. The action that the majority has been proposing today departs from this committee's established practices, including its long-time standing acceptance of written testimony and the level of accommodation this committee has traditionally required before proceeding to criminal contempt, not civil, criminal contempt. I'm glad, as the ranking member has stated, that the Clintons have agreed to testimony and to a transcript and to meet. I agree also that that meeting should not be taking place in New York. It sends the wrong reason for anybody that gets something from this committee. They should come to the committee. It's just that plain and simple. But it departs in many instances with the way this committee has moved on. And I say that because we never know this time next year who might hold that gavel and who on either side may want to go after the current president, his sons, his wife, his family, and anybody connected to him as a department head. I'm just pointing out the fact that it's a slippery slope. Now, does Bill Clinton have to defend himself? Absolutely, yes. It is a bit curious, however, why we are going after Mrs. Clinton I've not seen anything, as the gentleman from Massachusetts said earlier, that suggests that she ought to be a part of this in any way or has done something wrong or is complicit in this matter. And I would hope that there's some consideration, Mr. Chairman, to withdrawing at the very least that particular resolution. It just makes me think that this is a fishing expedition and that we want to dust her up a bit if we get her before this committee. Now, a couple of quick things. We're being asked to move forward holding a former president of the United States, again, not in civil contempt, in criminal contempt of Congress. And I'm going to tell you why it's an extraordinary step. Not that it's unprecedented, it's extraordinary, but it is unprecedented in the fact that we did not do that with Richard Nixon. We did not do that with Donald Trump. There was a subpoena, but there was never an attempt to find them in criminal contempt of the Congress or of this committee. It's an extraordinary remedy that's usually reserved for situations where a witness has clearly and willfully defied Congress after extraordinary processes have been exhausted. The majority has not demonstrated that standard so far. I do want to say also that we're in a situation where I don't think that anybody on the Republican or on the Democratic side of this committee is trying to defend former President Clinton. They're trying to find a way to make sure that we're consistent. So the reason we keep hearing the need to have Pam Bondi before this committee is that we're getting ready to bring criminal contempt charges before there's been an investigation. Usually that happens after the investigation. And the notion that somebody is going to come before this committee, Mrs. Maxwell, and take the fifth, I don't care. She's already a convicted criminal. She can't take the fifth. But we can do the actions we ought to be about, and that is to make sure that both of them are before this committee, and then to make sure also, or to suggest, it's up to you and the ranking member, that that meeting takes place and those transcripts are made available, and that Mr. Clinton comes before the committee with counsel so that we then are in a position to move forward. We're taking a big jump here without doing some of the things that we normally do. Now, I'm glad that Ms. Tlaib brought up the matter of victims. She's not here right now, but all of us sat in that room with those victims. It was gut-wrenching, and all of us made a commitment that we would prove that this institution could and would do the right thing. So we're challenged here, Mr. Chairman, and I hope that you and the ranking member can give us a way to proceed here, that both of the concerns on both sides are addressed. But if we just move straight as we're going now without an investigation, it begs the question, what happens when the shoe is on the other foot? I yield back.
Gentleman yields back. Ms. Simons next. Before I recognize her, I just want to add, with respect to the Hillary Clinton subpoena, you all voted for that. This committee voted for that in a bipartisan manner. Her name was on that list. And with respect to Pam Bondi, again, she's testifying in front of Congress in less than 2 weeks. Chair recognizes Ms. Simon.
Thank you, Mr. Chairman. Just a quick comment, and I have a friendly question for my colleague, Ms. Luna. And I'll say a friendly question. I've worked with victims for decades. So few opportunities present themselves for victims to sit face to face with folks who hold power, to beg and plead that everyone who had anything to do with their harm be held to account. So few opportunities. I have been a victim advocate where brilliant young women who have been trafficked across this country have stood in courtrooms and were demanded to testify against their traffickers, and they did with such power and grace, in fear that their lives may be taken because of that braveness. And a number of those young women that I witnessed take all that they had to confront their demons, they were murdered because they took a stand. And so when we did stand in front and sit in front of those victims and they gave us their all, I hope that this is not the only opportunity, Mr. Chair, to speak on their behalf. from our president to everyone in those files. Forget all the political games. If these women who are connected with the largest sex trafficking ring in modern day American history cannot get justice, what about the girls in every single state? I mean, it is what it is. That being said, Ms. Luna, you talked briefly about a proposal.
She's not in.
She's out.
That's both.
There was a proposal put on the table to rethink how we might have a conversation about the Clintons or President Clinton coming in and having a conversation with this body. And I guess that time has passed, but I know that I would love to hear from the former president of the United States. I would love to hear from the Attorney General. I would love to hear from the current president of these United States. The victims deserve to be heard. The victims deserve for the files to be released in their entirety. And the victims deserve for us to get to the bottom of this matter. I yield back. Well, I actually would like to yield my time to the ranking member.
Actually, I'm okay right now on time. I might come back around, but back to Mr. Comer and the Republicans. Thank you, Ms. Simon.
Okay. Do any other members seek recognition? Seeing none, we are going to, there's an amendment at the desk. Well, let's Ms. Lee, what purpose do you seek recognition?
I have an amendment at the desk.
Will the clerk distribute the amendment to all members? The clerk will designate the amendment.
An amendment to the amendment in nature of a substitute to the William J. Clinton contempt report as offered by Ms. Lee of Pennsylvania.
Without objection, the amendment is considered as read. I reserve a point of order. The gentlewoman is recognized for 5 minutes to explain her amendment.
Thank you, Mr. Chair. I think that even listening to this debate throughout our hearing today, our markup today, I think it's really clear that at the heart of this effort to release the Epstein files are very real human beings who have experienced unimaginable harm. They have been repeatedly victimized by the indifference of the U.S. government and the injustice that they face. They deserve peace and healing and justice. When my motion to subpoena the Epstein files passed, this committee resolved to get that justice for those survivors. And I thank Chairman Comer for pushing this effort forward by issuing additional subpoenas for the Epstein estate and the banks. And we know that without the full files from the DOJ, that is just not enough. That's why I'm introducing this amendment, which holds Attorney General Pam Bondi in civil contempt for failing to comply with the August 5th subpoena, and I urge my colleagues to support it. And we believe that we should start with civil contempt because we are serious about this investigation. We want these files and we want to hear from them. And we must start there. The Department of Justice needs to be the priority. We can move to non-compliance by anyone else, including Ghislaine Maxwell, after we have received those files. It has been 5 months, and we're still missing over 5 million pages of documents purportedly. The Department of Justice has only released 1% of those files. They have stonewalled this committee since August, and they have failed to provide even the most basic updates. How is that not an insult both to the authority of this committee and the survivors? Without the full files, how can we know who might have legitimate knowledge or who might be culpable? We wouldn't have to speculate on the Clintons or anyone else's involvement if we had all of those files. And to be clear, I'm certainly not opposed to the President and Secretary Clinton being held accountable for violating the subpoena. But the fact that this effort to hold the Clintons in contempt was fast-tracked and is happening before any action against the Justice Department is just evidence that the Republicans on this committee are not taking this investigation seriously. It is an unequal application of law. And again, it is a bit ironic that these contempt resolutions empower the Justice Department to imprison possibly 2 people for defying the exact same subpoena that they themselves are defying. If this committee wants to be taken seriously, we would be addressing all of the bad actors in this investigation, not cherry picking them for political points. The Justice Department needs to be held accountable for their non-compliance and lack of transparency. They have been selectively producing information, shielding powerful people, and obstructing any efforts for oversight. And if we don't hold them accountable, Mr. Chair, we are too. Just this past Friday, Attorney General Bondi asked a New York federal judge to deny an appointment of a special master to monitor the release of the Epstein files. They don't want a neutral third party making sure they follow the law. I think all of us should be questioning what the Justice Department is doing that they don't want the American people to see. We can't just take them at their word that they'll eventually get around to releasing the files. Quite frankly, they have put up the same, if not far less of an action as the Clintons have. What little information they've released so far has either already been made public or has been a mess of just sketchy redactions. A group of survivors sent a letter to the Justice Department's Inspector General complaining that the redactions had been, quote, selective. They pointed out that multiple times the names of alleged abusers appeared to be redacted, yet some survivors' names and identifying information were released. To be clear, the subpoena I moved to secure does not allow for redactions unless it would protect the identity of a survivor or contains child sex abuse materials. They have had plenty of time to work with this committee to protect survivors' identities. This is bigger than one case. It's about rich and powerful people being protected by each other and institutions. It's about a system that has enabled Jeffrey Epstein and Ghislaine Maxwell and whoever their co-conspirators are to buy favors and silence from our government. This effort is the one time we could get some real accountability and reclaim the power of this system. Republicans, don't drop the ball by allowing Pam Bondi and the Department of Justice to play us for fools. Mr. Chair, you are setting a precedent that non-compliance with this committee will result in immediate contempt proceedings. So I challenge you and my Republican colleagues to put your money where your mouth is and pass this amendment in holding Pam Bondi in contempt. I yield back.
Gentle yields back. I'll recognize myself just for amendment. Look, I oppose this amendment, and I hope everyone on the committee opposes this. That's because Attorney General Bondi and the Department of Justice, they have released documents. Again, not at the speed or pace that any of us want, but they are complying with our subpoena. That is a fact. I oppose your amendment, Ms. Lee, because you amend the criminal to civil. And I think that most of what I'm hearing from my colleagues on the other side of the aisle is everyone wants to hear from the Clintons. They've had an opportunity for 5 months. They will have another opportunity between today's vote and the floor to come in and answer questions. Pam Bondi is coming in front of Congress in less than 2 weeks to answer questions. Your colleague, Ms. Crockett, I don't want to speak for Ms. Crockett, but I'm pretty confident Ms. Crockett's going to grill Pam Bondi, right? You agree with me? I would have won that bet. Is she coming with the facts? Is she coming with the facts? Well, we'll see. I think that's a good. She may. I hope she does. So I oppose this. Now, Chair recognizes Mr. Garcia.
Thank you, Mr. Chairman. I want to just start by saying I strongly support the amendment proposed by Congresswoman Lee. The House majority keeps saying that they believe that no one is above the law. Oversight Democrats certainly believe that, but the Attorney General is violating it with impunity in support of a White House cover-up every single day. We want accountability for her failure to comply with our subpoena for the full Epstein files that's been in place since the summer. She fails to comply with the Epstein Files Transparency Act. She fails to comply with the subpoena put in place by Representative Lee and the committee. This is clearly a White House-directed cover-up. Now, over a month after the deadline, only 1% of these files have been released. No explanation has been given for illegal redactions, again in violation of the law. Epstein survivors have reported that their names have appeared in parts of the document that were not redacted. And every day she continues to withhold files and conceals the truth. she continues to give Ghislaine Maxwell special treatment by moving her to a less secure prison that we all are aware, which is completely shameful. Now, Chairman Comer, you claim, of course, that the Attorney General was complying with our subpoena. I mean, that is absolutely false. 1% of the documents since a subpoena in place during the summer is not complying with our subpoena. Now, on August 5th, 2025, this committee issued that subpoena, compelling her to produce documents and communications. That subpoena unambiguously required the Attorney General to do that no later than August 19th of 2025. August 19th, not December, August 19th of 2025. On August 22nd, the DOJ made a single production of approximately 33,000 pages to this committee. All of those documents, however, were already public. The DOJ has made no additional productions to the committee pursuant to the subpoena. The DOJ has failed to provide specific information in response to repeated requests from Democratic oversight staff as to why the DOJ's timetable continues to move and why it's not fulfilled its production or the law. Now, in response to letters from our committee on November 25th, the DOJ transmitted a single letter in response to the committee's inquiries. They claimed that the DOJ was working to comply with the Epstein Files Transparency Act, which now, of course, we know they actually weren't doing because we actually haven't received very much. The letter made no reference to the committee's subpoena, no reference to DOJ's plan for compliance. The corrupt failure to comply with the Epstein Files Transparency Act is not just a crime, it also shows that the Attorney General has made no attempt.
More than half the committee, they were demanding that we subpoena the estate, and we did. We got every document from the estate. There were people who said, oh, there are going to be a lot of questions answered. There'll be names and all. We've subpoenaed every document, every picture, everything from the estate. We never held back. We've been serious. We've all supported the full release of the documents. As I've stated many times publicly, we wish the process was going quicker. That's a lot of documents, a lot of redactions, a lot of eyes have to be put on this. So the Department of Justice is complying. Now, with respect to Maxwell and the Clintons are not treated differently. Maxwell was always, she was willing to appear, but made very clear she would take the Fifth Amendment. The Clintons refused to appear. The Clintons refused to appear. And one of the proposals that Clinton made was if we would let Hillary Clinton off, then Mr. Garcia and I could travel to Mr. Clinton's house and bring one staffer and take notes, but no transcript. That's not even a thing. And you all know that. The media, I'm sure, would require a transcript. There's no real investigation without a transcript. So, what few counter proposals the Clintons' massive legal team has made aren't acceptable. And I don't think anyone is going to stand up here and willing to publicly argue that they were. So does any other member seek recognition? Mr. Frost.
Thank you, Mr. Chairman. The American people deserve full transparency, and anyone who has relevant information about Jeffrey Epstein's crimes must be compelled to come forward and share with this committee. Wealth and power cannot shield people from accountability from this committee. It is the victims of these horrific crimes who deserve protection, not Jeffrey Epstein and the people associated with him. We all agree. We want to hear from former President Bill Clinton. But committee Republicans have failed to conduct a serious investigation. For instance, they refused to hold Attorney General Pam Bondi in contempt for failure to release 99% of the Epstein files on a bipartisan law that we all passed on the House floor, and B, that had a deadline. And B, they refused to hold Ghislaine Maxwell accountable for defying this committee's subpoenas. We all know that President Trump has a long-standing relationship with Jeffrey Epstein. His administration continues to obstruct the release of the Epstein files for this reason. We've seen photos of them together. Even Elon Musk posted, @Real Donald Trump is in the Epstein files. That's the real reason why they have not been made public. President Trump's own Mar-a-Lago club appears to come up often in connection to Jeffrey Epstein. From reporting, we know that Epstein was deeply involved with Mar-a-Lago. He was a frequent visitor to the club for years. The club sent employees, usually young women, to Epstein's mansion for massages, manicures, and other spa services. Staff members from the club made frequent calls to Epstein's home in Palm Beach, and on these calls, Epstein engaged in sexually suggestive behavior, such as exposing himself. And in 2000, Ghislaine Maxwell recruited Epstein's trafficking victim from Mar-a-Lago, where she was working as an employee. This committee must also investigate what Mar-a-Lago club members and the staff knew about Jeffrey Epstein's crimes. Getting documents from Mar-a-Lago is about uncovering evidence, holding these people accountable, and doing right by the victims of these horrific crimes. So we are all for making sure that we hear from everyone. I don't care if you're a Democrat, I don't care if you're a Republican. I'm tired of rich people trying to evade justice and accountability, period. But you can't do it just for the party you disagree with. You can't do it in a politically motivated way. So here's the opportunity to show it's not a politically motivated thing. Let's also make sure that we get these documents from Mar-a-Lago. So with that, pursuant to Clause 2K6 of House Rule 11, I move that the House shall subpoena the Mar-a-Lago Club and all entities under common ownership or control with the Mar-a-Lago Club to provide the House Committee on Oversight and Government Reform with 1. All documents, communications, and materials related to Jeffrey Epstein, to include but not limited to personnel files and records, client files and records, massage and spa services records, complaints and grievances filed against Jeffrey Epstein, internal communications, and billing statements. 2. A list of all Mar-a-Lago Club personnel who provided massages on behalf of the Mar-a-Lago Club between 1997 and 2003, regardless of whether such personnel were contractors or formerly employed masseuses or otherwise. And 3, a list of all Mar-a-Lago Club personnel who were employed as or acted as managers of the Mar-a-Lago Club Spa between 1997 and 2003.
A motion was made by Mr. Frost. The motion is improper as the item is not on the agenda. Any other chair recognizes?
So Mr. Chair, you want to use procedure to push back accountability?
No, we're holding people accountable today. That's why we're here.
Well, why won't you move to make sure that we get the relevant documents from Mar-a-Lago? That I just read this, and you're saying it's because it's not on the agenda that we can't move forward with this? You have full discretion of this committee to say, you know what, let's have a vote in a bipartisan way to say we want the documents from Mar-a-Lago.
I don't have full discretion. It's in the rules. We vote on a rules package at the beginning of
You're able
Congress.
to say right now that we can vote on this.
We cannot vote on it. It's in our rules. We'll be breaking our rules. We have to apply to the rules too. We're not like the Clintons.
No. You are hiding behind process to protect these Mar-a-Lago documents, and I think it's disgraceful.
Chair recognizes Mr. Cloud.
Thank you, Mr. Chairman. One thing was noted in the Clintons' letters is they said the subpoenas were illegal. I'd be curious to know if the ranking member thinks that they're illegal. And with that, I'd yield the rest of my time to you.
Thank you, Mr. Cloud. I want to make sure everyone is aware. On February 11th, Attorney General Bondi will be appearing as the sole witness in front of the Judiciary Committee. Ms. Crockett is a member of the Judiciary Committee. I would assume, I don't want to speak for Ms. Crockett, but I would assume you'll ask her questions about the Epstein investigation and her progress towards releasing the documents. Mr. Massey is a member of the Judiciary Committee. He's already stated publicly he's going to spend his 5 minutes asking the Attorney General about the Epstein documents. So the Attorney General is slated to be in front of Congress, and I'm pretty confident that just about everybody on that committee is going to ask the Attorney General where we are with the document production. So I think that's important to note. February 11th, she's slated to be in front of the Judiciary Committee. And with the discharge petition, when the House voted for that, we issued the subpoenas for the Epstein documents. Then we all voted for the discharge petition. The discharge petition has jurisdiction in the Judiciary Committee. So she's going to be in front of the Judiciary Committee. The next week we're in session. So I think that's important to note. Do any other members seek? Okay, Mr. Lynch, then, yeah, go ahead.
Thank you, Mr. Chairman. I would remind the gentleman, and I'm sure he knows this, that the Oversight Committee is the principal investigatory committee in the House. And we have a responsibility. It may be a shared responsibility with judiciary, but we nevertheless have a responsibility. And we are the ones who issued that subpoena. This committee did. We are the ones who sat with the victims, right? We looked them in the eye, including the Speaker of the House. We looked them in the eye, these women who have been struggling to get justice for many, many years, and we promised them, every member of this committee, we promised them that we would do everything under our power to make sure they finally receive justice. And here we are today. Now, with millions and millions of documents requested back in August, we've still received, what, 1% of the documents? This is evidence of wrongdoing in many cases. And yet we're allowing Attorney General Bondi to obstruct justice, basically. Even the little bit of evidence that she has provided, she also included a statement that basically said, don't believe this evidence, there's a lot of falsity in these. I mean, I have never seen an attorney general in this country provide evidence and then give an opinion on that evidence to the legislature, to the Congress. That is unheard of. But it shows her willingness to do whatever she can to obstruct justice from being delivered. The second thing I want to say is, if we are truly interested in getting information relative to this investigation, there should be some underlying basis for that. And I have reviewed all of the evidence that's been made available so far. I find nothing that points to Secretary Clinton in this at all. Yes, she was Secretary of State at one point, but the information that we're trying to get with respect to Secretary of State is available from any Secretary of State that served in that office with respect to trafficking. So there is no direct reason, no direct evidence to point to Secretary Clinton in any of this. And yet, while those millions of documents are being denied us, we're pulling someone forward, I think, for the point of embarrassment, public embarrassment, and because of ill will on the part of the president, to bring her forward for embarrassment, but not for the purpose of gaining helpful information for this investigation. Mr. Chairman, I'll yield the balance of my time to the ranking member, Mr. Garcia.
Thank you, Congressman Lynch. Mr. Comer, I just want to be just pretty clear about two things, and one particularly something that you said. Let me just start by saying that you noted in your comments that your concern and your biggest concern was the issue of the transcript. And I want to just go back really quick, because you and I share respect for subpoenas. Mm-hmm. You and I share that we want the former president to answer questions. Is that correct?
Correct.
Great. And so does every other member of this committee. We want the former president to answer questions of this committee. And we want not just the former president, but everyone to follow subpoenas of this committee. So let's agree on that. But to be clear, President Clinton, the former president, has submitted a signed declaration. He's offered to sit with you and me and answer questions. He's offered to have staff in the room to transcribe and be there while those questions are being answered. And his request was to do it in a dignified way. Your concern, as you brought up in your last comments, was that he was unwilling to do a recorded transcript. That's actually also not true. And to be clear, there's been public reporting, including in articles that came out over the weekend, that they have not ruled out a recorded transcript. I want to ask the president questions. Chairman Comer, I want to ask President Clinton questions. Don't you?
That's why we're here.
I want to ask President Clinton questions and a recorded transcript and with our members of our staff. Would you like to do that also?
May I make a comment on the transcript? They have not agreed to a transcript. Staff notes are not equivalent.
They've actually made public reporting.
So they're wanting me to make note. They said, okay, Comer can take notes, but they've called us all liars, and you know how the Clintons have gone on offense, and look, they don't get to make the rules. We make the rules.
Can I have the rest of my time back?
Yeah. Go
Okay,
ahead.
thank you. I want to be clear because this is an email actually that from the Clinton lawyers. You have this actually. To be clear, at no point were we opposed to the creation of a record of the interview, which is why we offered to allow the note takers previously. They go on. This is, you have this email, sir. So I guess my question to you is, do you want to sit down and ask President Clinton questions? Actually, can I have my time back?
Well, the ranking member. We'll recognize Garcia, then Mr. Donald will be next. So
thank you. So my question to you, Mr. Comer, again, is if we want to actually ask questions of President Clinton, of which those of us in the minority want to do, then let's get him in. Let's negotiate a recorded transcription of that interview to further our investigation. I thank you for the yield, Mr. Lynch.
Time's expired. Chair recognizes Mr. Donalds.
Yeah, Chairman, point of clarification. Both President Clinton and Secretary Clinton were subpoenaed by this committee to come in for a transcribed interview. Is that correct?
For a deposition.
Excuse me, for a deposition. Chairman, I've been in these closed depositions a number of times in my time being on the oversight committee. I fail to see what President Clinton's talking about with respect to a dignified manner. Every time I've been involved in any of these conversations, even when it was former President Biden's son came in for one of those, and I'm not trying to bring up all the Hunter stuff, it's just a point I'm making. I think everybody just take the temperature down, relax. Even those the closed door depositions have always been held in a dignified manner. Members have had questions outside of questions from committee staff, but members on both sides of the aisle had an ability to answer those questions. Those interviews are recorded. The transcripts of those interviews are provided to the public. I fail to see what special accommodations President Clinton and Secretary Clinton were looking for. Chairman, can you help me understand this? Or even a ranking member. I'm really trying to understand. I'm not trying to make a point. We do too much of that here. I'm trying to understand, because if we're holding a new meeting to replace what the committee already requested, my question is why?
Mr. Garcia is willing to answer the question.
Yeah. Thank you, Mr. Donalds. I appreciate the question. Look, I think the committee first, I'm not here to defend the Clintons, to be clear. That's their job is to negotiate with the committee, and in this case, you have the majority. Their job is to negotiate with the majority on coming in for a binding subpoena, to be clear. But I'll also note that this committee has historically made accommodations for a variety of folks. In fact, I think it is a bit hypocritical that when this very subpoena for the Clintons were actually made, I believe there were an additional 5 to 6 other subpoenas that were issued to numerous other members of former administrations, attorney generals, and so forth. Every one of those other subpoenas, I think maybe with the exception of one, were given special accommodations. In fact, they were actually allowed to just send their responses in writing. Is that correct, Mr. Comer?
That is. May I respond to that?
Yes, in just one second. And so accommodations are made. And so while every other folks in that group were given special accommodations, that's been typically the case. And I'll finally say just this. Like you, I want to have President Clinton answer questions. I think they are trying to negotiate that with the majority, and they have been clear that it being transcribed is not an issue. They have not ruled that out. And so let's negotiate with the Clintons and let's get them to answer our questions.
Chairman, since I guess we're on my time, and by the way, ranking member, thank you for that. I appreciate that. Chairman, you were mentioning you were going to inject your commentary with respect to special accommodations that have been made for previous witnesses. I don't know if you want to expound on what the ranking member said or not.
I would love to. So, first of all, you talk about ongoing negotiations. We have been negotiating for 5 months. This is clearly a stall tactic, hoping that the time clock runs out and the House flips and that you all let them off the hook. But secondly, you mentioned, and I mentioned this in my open statement, there were names on that initial list with the Summerlee motion and the Scott Perry amendment. Attorney General Holder, Lynch, Sessions, and Garland, as well as Comey, they all complied and had written statements under the penalty of perjury that they had no knowledge of anything with Epstein, that they weren't directly involved in the investigation and, basically had no personal relationship. I think we would all agree the Clintons had a personal relationship with both Epstein and Maxwell. It's from the evidence that we've received thus far from the estate and all the other documents that we have thus far, it appears that Jeffrey Epstein visited the Clinton White House 17 times while he was president, and then post-presidency, it appears that Bill Clinton flew on Epstein's plane at least 27 times. So there's a huge difference between the knowledge and relationship with the Clintons and Epstein and Maxwell versus the former Attorney General. And another note, I don't know if it was Mr. Bell or whoever said that we only are interested in Democrats. We grilled Bill Barr and Alex Acosta, and they are very Republicans. In fact, they were members of the Trump cabinet. Now, I've been on the Oversight Committee 9 years. We've had 4 other committee chairs. We've had since I've been here, we've had Jason Chaffetz, Trey Gowdy, Elijah Cummings, and Carolyn Maloney. I don't ever remember a time, and I could be wrong. If I am, I'm sure you all will correct me, but I don't remember a time when Carolyn Maloney or Elijah Cummings subpoenaed a high-ranking Democrat to come in for a grilling. So to imply that this is partisan, that is just simply not true. We've already had 2 very high, the former Attorney General of the United States under Trump and the former Labor Secretary and U.S. Attorney. So we've done that. And then one other thing with the Clintons, and I'll yield back. One of the arguments the Clintons made, Mr. Garcia, was that our subpoenas were unlawful. Do you agree that the subpoenas we issued the Clintons are unlawful?
I believe that all of our subpoenas that we have issued have been lawful, sir.
Okay. Just any other members seek recognition?
Ms. Brown, sir.
Ms. Brown. Ms. Brown.
Thank you, Mr. Chairman. It's clear to me that the purpose of this meeting today is just to continue this committee's agenda of political theater, plain and simple. Democrats have been very clear, abundantly, repeatedly, and without room for ambiguity. We want to hear from anyone who has information about the Epstein crimes. And yet, when former President Clinton and former Secretary Clinton offered to cooperate with this committee to submit sworn statements, to provide what they know, to engage in good faith, the majority said no. And that's what brings us to why we're really here today. The majority is rushing to hold in contempt 2 private citizens who have demonstrated their desire to cooperate with this committee and who have called for the release of every file on Jeffrey Epstein, all while the Department of Justice and Attorney General Pam Bondi are breaking the law in plain sight. Here are the facts. The DOJ was required by statute to release the Epstein files by December 19th, 2025. The deadline has passed by more than a month. And what have we received? 1%. 1% is not compliance. 1% is not transparency. 1% is a cover-up. What about the 1% they actually release? We've seen redactions that are extensive, unusual, and very likely illegal. And what's more, the Epstein Files Release Act, passed by supermajorities in this Congress and signed into law by this president, required the DOJ to send a report to Congress by January 3rd, 2026. More than 2 weeks later, what have we received from the DOJ? Nothing. So if my colleagues on the other side of the aisle were really serious about uncovering the truth and government and accountability, we would be demanding answers from the administration. We would be demanding answers from Attorney General Bondi. We would be demanding the release of the 99% of the Epstein files still sitting at the DOJ. So I have some very simple questions. Where is the subpoena for Attorney General Bondi? Where is the hearing on DOJ's failure to comply with the Epstein Files Transparency Act? Where is the accountability for the redactions page after page after page? This vote feels less like oversight and more like a distraction. A distraction from the DOJ's lawlessness, a distraction from a broken promise of transparency, a distraction from the embarrassment of a co-equal branch of government choosing complicity over accountability, and a distraction from survivors who deserve the truth. If this committee is serious, then we must hold the Department of Justice accountable. Release the files, all of them, and stop playing politics with justice. Survivors deserve better. And with that, I yield the balance of my time to the ranking member.
Thank you, Representative Brown. I just want to Chairman, I want to just respond to something that you said. I think it's important. First, I just want to read the folks of who the subpoenas you have chosen not to enforce. Alberto Gonzalez, who we subpoenaed on that same day, I believe, you did not enforce. Eric Holder, of course, former AG, did not enforce. Loretta Lynch, you chose not to enforce. Jeff Sessions, you chose not to enforce. Merrick Garland, who I think it'd be important to have answer questions, you chose not to enforce. Robert James Comey, you chose not to enforce. In fact, I have Attorney General Gonzalez's letter. It says, "Dear Chairman Comer, this letter is to confirm that consistent with my conversations with the committee general counsel, I have no present memory or decisions or conversations related to the investigation and prosecution of Epstein matter during my tenure as U.S. Attorney General." He, of course, was the Attorney General when the whole Alex Acosta U.S. Attorney matter was in front of a critical time in this investigation. Now, you chose not to enforce that because you mentioned that this letter is under penalty of perjury. The declaration that Clintons also made and sent to you to answer some of those questions were also under penalty of perjury. I just want to clarify that. And then with the remainder of my time, Mr. Chairman, I think it's important to note that you talked a lot about the importance of our subpoenas and that we should all support this committee's subpoenas. And I agree with you, sir, and I want to hear from the Clintons. It's also important to note that we have members of this committee, Congressman Jim Jordan, Congressman Andy Biggs, Congressman Scott Perry, who are obviously very outspoken, which we like to engage with. Now, they're not here, and that's okay. Now, you also know, sir, that all three of them defied legally binding subpoenas issued by the January 6th committee relating to their efforts to overturn the 2020 election. So we should be clear that the majority chooses to be very selective on which subpoenas they want to enforce or talk about. We have members of the majority that themselves have defied subpoenas. So once again, I ask you, Mr. Chairman, let's ask President Clinton the questions that we have. Let's have him come in and testify in a way that we can negotiate, and let's get all the release of the files done immediately. Thank you.
Would you yield? Could I respond to that?
Sure, I have no more time, but I'm happy to respond.
So you say we didn't enforce the subpoenas. We did enforce. They complied and testified under the penalty of perjury that they had no knowledge. Now, the Clinton declarations were short bullet points, almost like talking points. And the evidence is clear that the Clintons did have relationship with them. Now, again, I've said publicly millions of times, there's no one's accusing the Clintons of wrongdoing, but the fact that they were that close, and the fact that I've never seen a sit-down interview with Bill Clinton where he's answered questions about his relationship with Epstein and Maxwell like the current president has. So we have complied and enforced all of our subpoenas, 100% of our subpoenas. So I just want to make that very clear.
Can I respond to you, sir? Sure. Just to be clear, you're talking about two declarations. The declaration that you chose to use as something that you moved on to not bring him in was 1/6 the size of the Clinton declaration. I'm looking at the Alberto Gonzalez response to you, sir, that you chose to dismiss, and it is one sentence long. You just pointed out the Clinton declaration, which is 6 times as long. And so I just think you are using interesting points to make comparisons. Let's just be clear and get back to the facts. Let's bring President Clinton in to have a conversation with this committee. You are instead choosing to try to prosecute President Clinton and send him to jail, which is part of criminal prosecution, before having him answer questions to this committee. Him and his team have been trying to negotiate. We want to hear from President Clinton. I'm not sure that you do, sir.
You don't think I want to hear from President
Chairman
Clinton?
Comer, can I, Chairman?
But before I recognize Ms. Luna, who'll be next, I believe, are you willing to accept those bullet points as testimony, or do you want to hear from Clinton?
I want to hear from President Clinton.
Then I don't know what the point is of talking about their bullet points. I mean, that we all know they had a relationship. So.
Well, sir, I'm just responding to the fact that you mentioned that you're dismissing other legal subpoenas with one-sentence answers. And you're the one that pointed out the Clinton's declaration, which is also under penalty of perjury.
Do you think that Eric Holder or Lynch or Jeff Sessions or Merrick Garland had more? I mean, do you want to bring them all in?
I would love to have former Attorney General Merrick Garland in front of this committee to answer questions as to why more of the files weren't released. I've actually said that publicly. And so, sir, I think what it comes down to is we all want to get to the truth. We all want justice for the survivors. And I think more information is better. And so I think our position is that it is clear to me that President Clinton is negotiating to come in front of this committee. And it may not be exactly what you and the lawyer and your team want to see as far as that negotiation, or you're not satisfied with the progress, but they continue to negotiate. They have not rolled out a transcript. Let's get them in front of this committee. Thank you, sir.
Chair recognizes Mr. Gill, then Ms. Luna. Mr. Gill has a bigger. Go ahead. No, Miss. Who's next? Ms. Luna. Go ahead, Ms. Luna. Then Ms.
Thank you,
Mays.
Chairman. I'd just like to remind the American people that I was the member that made the motion to hold Merrick Garland in contempt of Congress, and every Democrat voted against it. And in addition to that, 3 of my Republican colleagues voted against it, one of which did not.